Hi friends, in this video, we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now, in the area of negotiable instruments, that too, in relation to matters involving no offence for dishonour of cheque under Section 138 of the Negotiable Instruments Act is made out, if the cheque is presented for the full amount, without endorsing the part payment made by the borrower, after the issuance of the cheque. To know more about the cheque dishonour case, please watch this video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled, Dashrathbhai Trikambhai Patel vs Hitesh Mahendrabhai Patel and another pronounced on 11th October 2022, the Supreme Court has held that, no offence for dishonour of cheque under Section 138 of the Negotiable Instruments Act is made out, if the cheque is presented for the full amount, without endorsing the part payment made by the borrower, after the issuance of the cheque. The facts of the case would be that, the cheque was issued for an amount of 20 lakh rupees. After the cheque was issued, the borrower made a part payment of 409,315 rupees to the drawee of the cheque. However, the cheque was presented for 20 lakh rupees, without endorsing the part payment. When the cheque was dishonoured due to insufficient funds, the appellant filed a criminal complaint against the first respondent for the offence under Section 138. The trial court acquitted the first respondent on ground that, the first respondent paid the appellant a sum of rupees 409,315 between the 8th of April 2012 and the 30th of December 2013, partly discharging his liability, in respect of the debt of rupees 20 lakhs. On appeal, the Gujarat High Court upheld the judgment of the trial court acquitting the first respondent. Being aggrieved, the present appeal has been filed. The issues posed for consideration is whether the offence under Section 138 of the Act would deem to be committed, if the cheque that is dishonoured, does not represent the enforceable debt, at the time of encashment. The Supreme Court has held that, the cheque that is dishonoured, must represent a legally enforceable debt on the date of maturity or presentation, for the commission of an offence under Section 138. If the drawer of the cheque pays a part or whole of the sum between the period when the cheque is drawn and when it is encashed upon maturity, then the legally enforceable debt on the date of maturity would not be the sum represented on the cheque. When a part or whole of the sum represented on the cheque is paid by the drawer of the cheque, it must be endorsed on the cheque as prescribed in Section 56. The cheque endorsed with the payment made may be used to negotiate the balance, if any. If the cheque that is endorsed is dishonoured when it is sought to be encashed upon maturity, then the offence under Section 138 will stand attracted. The first respondent made part payments after the debt was incurred, and before the cheque was encashed upon maturity. The sum of rupees 20 lakhs represented on the cheque was not the legally enforceable debt on the date of maturity. Thus, the first respondent cannot be deemed to have committed an offence under Section 138 when the cheque was dishonoured for insufficient funds. The notice demanding the payment of the said amount of money has been interpreted by judgments of this court to mean the cheque amount. The conditions stipulated in the provisos to Section 138 need to be fulfilled in addition to the ingredients in the substantive part of Section 138. Since, in this case, the first respondent has not committed an offence under Section 138, the validity of the form of the notice need not be decided.